Okay, right. Oh gosh, we've got a bit of feedback. Let's turn that down. All right, ladies and gentlemen, welcome. Welcome to this seminar. A bit of unusual technology here, trying to make things a little bit more friendly and a bit more casual. Can I just ask, first of all, if you could let me know in chat whether or not you can hear me? So I can see we've got quite a few people in. It's a nice cozy group. It's a nice cozy group of people. And yes, we can see. Thank you very much there, Alexander and Peter, who've confirmed you can both hear. So for the next 50 minutes or so, I'm going to be presenting what is sort of my take on adult dependent relative applications, the hardest application that you can possibly make. Is it? Share your thoughts. So good to see you all here, though. Thank you for joining us. I'll say some hellos before we start. Hello to Usha, Dipendra, Georgette, Peter, Nihal, Alexander, Khalid, Naeem, Nihal, Smita. I've got this all wrong now, Wasim. If I've missed you, say something in chat and say hello, and we'll join each other in chat. So grab yourself a drink. I've got myself a little hot drink as we sit here on this sort of beach cafe / pub. David, you're also here, I think, in the background. David Egborough from Chambers has been helping to set all this up. Feel free to say hello, David. Just let me know everything's okay at your end, and then we'll make a start.
All good here, Jonathan. Hello, everyone.
Excellent. Thank you, David. Hello to you. Right, here we go. So let's try and broaden some horizons, shall we? What an interesting approach. Okay, first of all, oh, that's me, by the way. That's me, and that's my Chambers. All right, so here's what we're going to be looking at. Typical ADR cases, sort of the classical approach. Pretty quickly, I'm going to be moving into atypical ADR applications and inviting us to consider how we might be able to succeed where perhaps the rules don't make it obvious that we could. I'm going to be looking at how we can encourage decision makers to stray away, perhaps, be a bit more experimental in their approach. I'm going to be talking about how to lose an ADR appeal, and generally, the last topic is just what we're doing the whole thing. We're trying to just sort of broaden our approach. So let's have a look at some history. Oh my gosh, I've just realized something very strange has happened with the screen. What's happened there? Wow, that's remarkable. Have I exploded? What's happened there? Let's see if we can fix that before we go on. When did that happen? Right, no, that's not working. Okay, 1 second. There we are, I'm back. Right, history. So before the 2012 changes, trying to get your relatives into the UK was obviously much wider than it is now. We remember it used to include aunts, it used to include uncles, if there were exceptional compassionate circumstances, and you could demonstrate financial dependence. Compared to what we have now, I wonder if you agree that that is a remarkably low hurdle. In 2012, the ADR rules came into play. Now, obviously, they used to be, oh gosh, I can't remember where they were in the rules. It's gone. But now, of course, they're in Appendix Adult Dependent Relative. The new version of the rules, so the post-2012, are regarded by MIPEX, an organization that looks at sort of global immigration rules. We're regarded as having the second worst rules for family reunion in the world. And I'll just show you here what I mean by that. So you can see here a table. In fact, let me make this full screen so you can see what I'm talking about. Now, it might be obvious now why we are in Brazil on this beautiful sunny beach, because Brazil is the best country in the world to bring in dependent relatives. And as you can see, the United Kingdom beaten only by Denmark in being an absolute nightmare. Let's let the legal team in from an unknown organization. Here we go, let's admit them. Welcome aboard, legal team. So we're just talking about a bit of background here. I will now move forwards. Let's look at some comparisons globally. In Ireland, you just have an income requirement. You want to bring your grandparents over, you just need to demonstrate sufficient income. If you're in the United States, or you just need to be naturalized, you can bring your parents over to settle. In Canada, you just need to be a permanent resident. In Australia, permanent resident, there's a condition about the number of children and an assurance of support, but fairly straightforward. Hong Kong, permanent residents, parents over 60 can settle. No additional conditions. This gives you an idea of why it's so difficult in this country. Let's have a look at some statistics. These are pretty, well, let me just preface this by saying that statistics that are available for adult dependent relatives are very poor. There are no real adult dependent relative statistics. You have to dig around in some weird categories, as some of you may have realised. But broadly speaking, it looks like it might be the case that adult dependent relatives, there have been about 2,500 applications in between 2012 and 2015, of which only 606 were successful. And then in the 3 years 2017 to 2020, there was a 3% success rate. And then in 2020, according to what I could find, there was only a record of 1 being allowed on application. So this really is how difficult these applications can be. Brought up some stats here for you. So we have, yes, you can see, look at those numbers. Look at 2017, 18, 19, 20, 21, combined less than 100 successful applications made. Let's get stuck into the meat of this, shall we? What are the ADR requirements? We will look at them in a bit more detail, but broadly speaking, you need to demonstrate 3 things. Number 1, you need to demonstrate that the person wanting to come to the UK needs care. They need care in some way. The second thing you need to show is they can't get that care where they are. And the third thing you need to show is that they meet some sort of financial requirement. We're going to go through all this in a bit more detail. Secondary requirements, as I call them, they're not really secondary. You need to prove all of these, but you've got to be outside the UK. So really interesting situations where a lot of people have become dependent, maybe around COVID, and they find themselves in the UK and they've become dependent and they really can't leave the UK now because they've become dependent on their children, sponsor, grandchildren, siblings, whatever. Technically, you can't succeed under ADR if you're in that situation. Interesting position. You've got to have a TB certificate if you're from one of the countries that requires it. Very easy mistake to make, it's not having one, and it's got to be from an authorised source. You've got to have the correct familial status. Of course, you can't be an aunt or an uncle. You can only be one of these. Mum, dad, grandma, grandpa, son, daughter, sister, brother, that's it. Very direct. And the sponsor has either got to be British, settled, or protection status, or they can be one of the people who gets settled status under the EUSS, but only under EU 14.1, so not as a joining family member. I'm just going to have a quick look at chat, see if anyone is in the chat asking any questions. Part 8, thank you. Part 8 of the rules, Alexander. That'll do, won't it? That's where the old rules used to be. Feel free to put anything in chat that you're thinking, any thoughts, any experiences you've got of difficulties. I'm very keen for this to be a very informal place for us all to just sort of chat about our work. So let's move forward. Right, little game for you. Okay, so I'm testing something out here. Little game. I'm going to give you some examples. Right, I'm not going to tell you where these are from. You may recognise them. I'm going to give you some examples of situations that the Home Office either thinks could be successful under Appendix ADR or would not be successful under Appendix ADR. So here's the first one. Example number 1. You've got a person, they're 25 years old, they've got a learning disability, so they can't feed, wash, or dress themselves. His parents have recently died. He used to live with them. His only surviving close relative is in the UK. He's been sending money for some time. This person, this young chap, I say chap, yeah, this young chap has been cared for temporarily by family friends since his parents' death, but they can't carry on. He can't meet the cost of full-time residential care, but his family's got enough money to care for him here in the UK. Right, now, we're going to try something here. I'm going to try and create a poll for you to participate with me. It should appear on your screen now. Is this a situation that the Home Office say could meet the rules or would not meet the rules? Options on your screens. Click what you think is the right answer and we'll see if you get it right or not. Could this meet the rules, this situation? Or would this not meet the rules? I'm going to click could for my vote. Right. Okay, we've got 5 responses in so far. It's a 50-50. We've got 6 responses. 3 people are saying could, 3 people are saying couldn't. Well, we can of course reveal. Is there a way for me to reveal this? Oh, you'll see the answer as soon as you've clicked it. This is a situation where the Secretary of State says this could meet the rules. All right, so let's blast through some more, shall we? Right, so let's have a look at some more examples. Here's example 2. 30-year-old, lived in Sri Lanka for many years. Parents are settled in the UK. Other siblings live in the UK and the USA. So they're on their own. They've been in a road accident and they've developed some sort of long-term condition, which means that they can't care for themselves. Mother's been visiting Sri Lanka to care for her son, but needs to come back to the UK because she's got younger children. What do you think? Did the Home Office say this could or would not succeed under the immigration rules? I'm going to say could. Oh, I got it right. I got it right. It's a could. It's a could. This situation could succeed. All right. So I may have done too many of these. Let's do another couple, shall we? Why don't we skip? Let's do example 3. 70-year-old, alone in India. She's got a daughter that lives in the UK. She's got a son, but his family and they all live in the UAE. The daughter sends her mother money to pay for someone to do a cleaning, but is concerned that mum's becoming increasingly frail and forgetful. Sounds pretty desperate situation. Sounds very sad. Let's have Zoya in. Welcome, Zoya. Join us. What do we think about this one? Is this a situation that could meet the rules according to the Secretary of State, or would not meet the rules? I think it sounds pretty desperate. I'm going to say surely she could meet the rules. I'm going to click my answer. There. We've got 6 responses in. Oh, I've got it wrong. Unfortunately, the Secretary of State says this person would not meet the rules. I'm not sure I agree. Let's skip on a couple, okay? We're going to go past example 4, past example 5. Let's have a look at example 6 here. Let's have a look at example 6. You've got a person here, 45 years old. They live in China. They were widowed, sadly, 5 years ago. They're disabled, and they can't perform everyday tasks for themselves. Looks like it meets some of the rules, doesn't it? They need care. Their son lives in the UK, and this person in China lives with their new husband in China. The son in the UK wants mother to come and live with him in the UK. Well, they're disabled. They can't perform everyday tasks. What do we think? Example number 6. Options on your screen. I mean, they're disabled, right? They can't perform everyday tasks. Their son lives in the UK. Surely they can come to the UK and be with their son. I'm going to say could. Nope. I've got it wrong, haven't I? I've got it wrong. This person does not meet the rules. Of course, the Home Office would say they don't because you've got a new husband in China and that new husband can look after you. Let's do one more and then we'll explain why the Home Office has got these wrong. Okay, massive example here. A husband and wife, they're both 70 years old. They live in Pakistan. The daughter lives in the UK. Wife needs long-term personal care. She needs care, right? Okay, we've got that established. But the husband, who's also in Pakistan, he's in good health, but he can't provide his wife with the level of care she needs. All right, so it looks like she needs care. He can't provide it. The daughter can. She doesn't work, and the husband provides the family with an income. The sister in the UK will help with the care of the mother, and the applicant provides the entry clearance officer with planned care arrangements for the UK. What do we think? Would the Home Office be happy with this one? I'm not sure. I mean, it looks okay, but why can't husband pay for care in Pakistan? Can't see a reason why not. So I'm going to say the Home Office would say no to this one. Options on your screen. What would the Home Office say to this? What would the Home Office say? I'm going to say the Home Office wouldn't accept this one. Bizarrely, in this case, the Home Office say this might succeed under the rules. But on the basis that you prove that care is not available in Pakistan. So let's do some of this work now for ourselves. The first thing we've got to prove, of course, we've got to prove three things in relation to dependency. We've got to prove that the dependency exists as a result of age, illness, or disability, that you require long-term personal care as a result, long-term, and it has to be personal. We'll come to that late in a later slide as to breaking that down. And it needs to be required to perform everyday tasks. That's the first part. The second part is that care must be unavailable in the country of origin. That has to be unavailable even with financial help, and it must be unavailable for one of two reasons. Either it must be not available and there's nobody that can provide it, or it must be not available because it's not affordable. Unfortunately, this creates a bit of a conundrum sometimes, doesn't it? Because affordability, okay, you say, well, I want to argue that I can't afford the care in, let's say, Pakistan, for instance, just because that was the last example. It's too expensive. But you've also got to prove that you meet the financial condition. Total catch-22 identified in a number of authorities. How can you possibly argue that you can't afford the care in a country of origin, but say, I can adequately maintain and accommodate this person because I have the requisite finances? It's a real problem. How do we get around this? Here's where I'm inviting you and decision makers to expand the scope of what the rules appear to allow. It's the word reasonably. So if we just go back a couple of slides and we just look here, it's this bit down here, right? This is what's doing the work. We need to prove that the care is unavailable, but we can prove it by saying that there's no person who can reasonably provide it. That word reasonably can do a whole load of work that you would possibly never imagine if you don't do many ADR cases. How much work can it do? Let's find out. We look at BritSits. Now, BritSits is a Court of Appeal authority. The one you want to use is the Court of Appeal authority. I just want to dip in for a moment to the High Court authority that preceded it. So I'm just referring here to the High Court authority of BritSits. Now, BritSits is an organisation that sort of exists to promote the rights of people that live in the UK, generally settled people or citizens. And originally, they brought a challenge in the High Court to the lawfulness of the immigration rules themselves, to the lawfulness of the entire ADR provision. And effectively, what BritSits were seeking to argue was that there was a number of reasons, three reasons principally, why the ADR rules were not lawful. One of them was they said, I'll just deal with two of these, because one of them never really got off the ground. The first argument that they made was under the 1971 Act, under the Immigration Act 1971, there is a specific requirement that requires the Secretary of State to promote the interests of dependents. And what BritSits were arguing was that the bringing in of the ADR rules was essentially a ban on dependents. It made it so hard for dependents to come in that it all but made it impossible. And we can see that. We saw that in the statistics earlier. So what BritSits were arguing was that it's incompatible with that duty under the 1971 Act to try and promote the interests of dependents. They failed, unfortunately. And the third argument, the third point that they made, I'm skipping the second one. The third point that they made was they said, there's no way you can apply these rules in a way that's compatible with applicants' Article 8 rights. And the High Court said, no. It wouldn't be unlawful on that basis on the Lebanon principles. In other words, it wouldn't be unlawful unless a decision maker would be totally unable to apply the rule in a manner that's proportionate. If a decision maker just couldn't use the rule and be proportionate, then that would make it unlawful, but we're not in that territory, said the High Court. And then, of course, the matter goes to the Court of Appeal. And the same arguments get ventilated. And one of the real concerns here as to the lack of an ability to make any decisions proportionately under the adult dependent relative rules was the catch-22s. One of them we've already discussed. So the first one, the catch-22, was you've got to both say that you can't afford the care, but you can afford to support the person in the UK. And that would therefore exclude, potentially, everyone, right? If there's a logical contradiction inherent to that requirement. But there's another catch-22 that Britsits advanced, and that is this. The first requirement, that you require care, right, that you've got some sort of issue as a result of age, illness or disability that means you require care, that has to be really bad. Right? But if it's so bad, you're going to require basically hospitalisation. And if you require that level of care, then your UK-based sponsor can't possibly accommodate you. Your care is simply too much. So there's two catch-22 situations that Britsits sought to advance. I'm just going to have a quick peek at chat, see if anyone is saying hello or anything, any questions. No questions at the moment, but throw them in. If you've got any questions, I might not be able to answer them, but I'll try. Right, where am I now? Here we are. Oh, gosh, that's not good. How's that happened? There we go, it's back to normal. Right, good. So let's go further into the Britsits Court of Appeal case. This Britsits case is everything for ADR success. What the court said in Britsits, what the Court of Appeal said, first of all, very important observation. The Court of Appeal noted that for decision makers, the focus, as in the focus in the rules and the focus in the guidance, the court said, is clearly on whether or not the care that's actually required by the applicant can be reasonably provided and to the required level. Right? So I said the word reasonably was doing a load of work. The court here is saying that the words the required level is also doing loads of work. And the Court of Appeal is saying that is the focus of the ADR rules. Really important provision. What else did the Court of Appeal say? They said that care in the home country must be considered as to whether or not it is reasonable from both the perspective of the potential provider of the care and from the perspective of the applicant. And the court said in Britsits, the standard of such care must be what is required for that particular applicant. So, what does this mean? This means the Court of Appeal is saying, let's focus on these specific provisions in ADR. Let's focus on them and let's make the whole point of these applications to question what would be reasonable from the appellant's perspective or the applicant's perspective. What would be reasonable from their perspective? So, for example, are they of a certain religion that says it may be not appropriate for you to receive intimate care from a member of the opposite sex? Right? That's a concern about what's reasonable from their perspective. But similarly, what if the Home Office is saying that a family member can provide this care, but that family member has a similar objection? Right? I don't think it's appropriate because of my faith or my beliefs generally. I don't think it's appropriate for me to provide this care. That's a reasonableness question, isn't it? From the perspective of a provider, from the perspective of the applicant. What if the only way that the applicant could receive care would be to travel to a part of their country where they've never lived, and it's you know, hours of travel away? Is that reasonable from the perspective of the applicant? I would say not. The second point of focus given to us by Britsits is what is required for that applicant. And yes, I can see that the Court of Appeal here has referred to what standard of care is required, but in my view, it goes beyond standard. It goes into form. What form of care is actually required by this applicant, right? So do they simply require quite straightforward, I'm going to cook some meals for you, I'm going to help you move around? Is that the kind of care that they require? Or are they reaching a point in their lives where what they need is psychosocial care? Right? Do they need, is the standard of care that's required inclusive of, I need to be with a family member, and if I'm not, I won't be able to live my days well? Let's think about that as we move forwards. Just gonna have a quick peek at the chart. Oops. How do I do this? Seems you're all happy, I assume. Silence may not be an indication of happiness, I don't know. Right, let's move forward. The court also said in Britsitz that these considerations about reasonableness and provision of care, include questions about accessibility and geographical location. So as I alluded to before, if there's a care home in the country, but it's 5 hours away, and it's part of the country where you've never been, and you don't know anyone there, is that reasonable from the perspective of the applicant? The court in Britsitz said these are specific considerations that decision makers should have regard to. And possibly the most important sentence in all of Britsitz is this one. These considerations about reasonableness and about the standard of care required, the Court of Appeal said, are capable of embracing emotional and psychological requirements. Non-physical, right? There is nothing in this page that says it needs to be a physical disability or a physical issue that means you require care. It can be emotional, it can be psychological. There is a huge caveat to that though, and that is if you are relying on emotional or psychological requirements in saying this is the type of care that I need and it can only be reasonably provided by a family member, Britsitz says that needs to be verified by expert medical evidence. And interestingly, that is reflected in the Secretary of State's guidance as well, where they say we would expect to see evidence from a doctor or a similar care provider level. Really important points, and I have seen applications fail for this reason. It's obviously expensive, but it's necessary. There is, before we leave Britsitz and start to explore sort of the wider concepts that it leads to, Britsitz does give us a very significant warning. If you're not capable of succeeding under the rules, if you have to argue that Article 8 is the means by which you succeed, if you end up engaged in a proportionality exercise, it is absolutely not automatic that Article 8 is engaged by a relationship in this category. It is not enough that they are your parent. It is not enough that they are your grandparent, sister, brother, child. You have to demonstrate through the Huang principles, you have to demonstrate that Article 8 is engaged. The burden is on us to prove that Article 8 is engaged. There has to be, and it's specifically referred to in the judgment, there has to be something more than emotional ties. So bear that in mind if you're going outside of Article 8. Now, why can't I go forwards? I can go forwards. Excellent. So to summarise, what do you need to do to succeed in an application for ADR? Broadly speaking, you need to do, I think I've got about 7 things on this list here. The first thing you need to do is you need to prove that care is actually required for the completion of daily tasks. The second thing you need to do, well, the second thing you need to recognise is that this does not include a requirement, that this includes a physical ailment. That's not necessary. But if you're going outside of physical ailments, you will definitely need expert medical evidence to go there. Also, you have to show that whatever required level of care is necessary is not available. If it is available, look at accessibility, look at geographical location of that care. If that doesn't create a problem, look at whether or not there are emotional and psychological requirements, but support those with medical evidence. That expert evidence must show, in order to succeed, that an applicant's emotional and psychological requirements are not being met in their home country. And what it really should say, in order to succeed, is this person's emotional and psychological requirements are as follows. They exist as a result of whatever condition it might be that creates them. You really want an ICD level diagnosis, and then you want a finding that says the only person that can provide the required level of emotional and psychological support is the sponsor or a member of the sponsor's family or what have you. It's still a high burden, but it can be met with the right evidence. So, what I promised I would do is sort of approach this now in a how to lose point of view, from a how to lose perspective. These are the ways, in my experience, that ADR applications and ADR appeals are, practically speaking, lost in the real world. The first one is to be relatively healthy. Unfortunately, I do see applications that fail to make out the initial provision quite often, and simply say, this is a person who is elderly, this is a person who has arthritis, who has glaucoma, who has diabetes, who has edema. In my opinion, any of those conditions are not normally enough to satisfy the first requirement to show a need for care. They are very, very common. And it is absolutely not the case that people with hypertension or arthritis all require care. If that is the health condition that you're relying on in an application, I don't think it's enough. I think what you need is medical evidence that explains why those conditions prevent somebody from completing daily tasks. They can do that, but all too often I don't see the causal connection being made out in the application. The second way to lose, really easy way to lose an ADR case, this. Remember that you don't just have to show that any care is required. It has to be personal care. Now, most of the time, these applications do meet this requirement. Most of the time, that the kind of care that's required is personal, but it's not set out. It's not set out in the application. And you can't rely on the application form, because the application form is useless. It does not ask these questions. It does not say, describe to us how the care that's required is of a personal nature. And because the form doesn't ask the question, it never gets completed, or rarely gets completed, and as a result, it is one of the mechanisms by which the Secretary of State can say, you failed to show us how it's personal. Examples of non-personal care are, you need medication. Okay, that's perhaps not a personal form of care. Giving the medication might be, but needing the medication isn't. Also, the requirement for mechanical aids, that's not a personal form of care. So all I'm saying here is, in the application, make positively the case. The form of personal care that is required is assistance with washing, assistance with having the medication taken. It has to be personal, and it's not made out sometimes. The third way to fail is to fail to identify the daily tasks. Now, I say this because sometimes there is general reference made. This person is unable to complete daily tasks. No, I need to know in detail, exactly what the daily tasks are and why they're not being met. For instance, what happens if this person tries to go to the toilet on their own, right? So you're saying that they can't. What happens when they try? I know it sounds grim, but we have to be specific about these things. Have there been any incidents where they've tried to use the toilet themselves and they've fallen? Is there a loss of dignity that's concerned? Are there hygiene issues that result? The same goes for showering, bathing, cooking and eating. It's not enough to say this person can't cook for themselves, this person can't eat for themselves. Make it more specific. Are they suffering from a lack of nutrition as a result of it? Do you have medical evidence that says this person is suffering from malnutrition and it's because they're not cooking for themselves? We have all seen those cases. The point I'm making is that sometimes it's just not made clear enough in an application. The one that I do want to leave on point 3, though, is this. Socializing is a daily task. In my opinion, socializing is a daily task. It is not enough for a person to just live and bathe and eat and take their medicine. That's not an existence. In my opinion, if a person can't socialize, then they're not completing a daily task. Even if that's the only daily task they're not completing, in my opinion, that's enough. So we're talking about broadening the horizons of what ADR applications can be. Let's just pause here. I have had success with applications where the way in which the applicant is suffering is severe depression, that they are living on their own, maybe they've been widowed, they don't have a physical ailment in the traditional sense, but they are so objectively miserable that they just don't leave the house. And it's because of depression. And we have medical evidence to say this person is suffering from severe depression, and as a result of that, they're not going out. That, in my view, is an inability to perform a daily task. And we should be arguing that more often, because I think there are these people. I think there's lots of them. Another way to lose is to fail to describe which of the three causative mechanisms that lead to a requirement for care actually exist. All too often I see it said that it's as a result of age, illness, or disability. In my view, there is absolutely no harm in picking one. There'll always be one, right? There'll always be one that stands out amongst the others. In my view, the best application is one that says it's because of age, right? We're not saying disability, or we're not saying they're old. It is disability. Pick one. I think that's the best approach. One of the most common ways that I see applications fail is by an applicant failing to actually address their current situation. It's perhaps easily done because I think a lot of applicants think it's obvious, but it has to be addressed in writing, in a covering letter. Again, the form will not ask the right question to get a good answer for this. Most of the time, in most of the cases I see, the reason why the person is making the application is because there's been a change of circumstances. Right? The person that used to provide them care has passed away. And yes, most of the time in those situations, there's a death certificate that goes in and there's witness evidence. But in my view, it's not enough. I think most judges want to see a full chronology. In other words, when did the requirement for the care begin? And it might have been a decade ago. Who has provided care over time? Setting it all out in a chronology. Have people dipped in and out? Have there been people from the UK flying to this country, providing care? Showing a chronology where that happens. Set things out that way. If that's not the case, the other situation that I do see a lot of is actually they're not currently able to survive. They're literally managing to stay alive, right? But they're not existing in a meaningful way at all. Things are, as I say in the slide, things are already absolutely terrible. These are the applications that I think are the ones that generally come with an application for urgent consideration. You're writing to the tribunal asking them to expedite things. That can be done, and I've had success with that as well when the health is that bad. But again, I think that requires expert evidence. I think that requires an expert report that says, here is the way in which this person is living. Here is how I know about this. I had a video conference with them. I could see the room behind them. Whatever the case may be, they're living in squalor. They're living in a destitute situation. That means that the Home Office cannot say, well, you're fine as you are. But it needs to be well evidenced. Bear with me just one moment. Aha. We have some questions. I'm going to just dip into chat for a second. We've got 15 minutes until the end of the seminar, so fire your questions in. Alexander asks, could that psychosocial care include a relationship with minor grandchildren? Absolutely, yes. It's a great question, Alexander. It all depends on the facts of the case, right? But there is no substitute, in my opinion. There is nothing like the relationship between grandparents and grandchildren. It is a genuinely unique form of familial relationship. If it is the case that the applicant is depressed because they are not seeing their grandchildren, right? And for example, it might be the case that the grandchildren can't fly out for some reason, that there's some barrier to that. That might be a financial barrier. If that's what's making the applicant depressed, then I do not see why it's not possible for an expert to prepare a report, be asked the question, please could you comment on the way in which the absence of grandchildren from this applicant's life is affecting their mental health, I don't see why an expert can't say it is affecting their mental health, and therefore the only way in which their depression is going to be treated at the required level of care is to be reunited with their grandchildren. And the only way that can happen is by them coming to the UK. I am sure that applications can succeed on that basis. Just has to be supported by expert evidence. Smita says, a real issue for applications like this and obtaining expert evidence is the impact of delays in decision making. Right now, in-country ADR type applications are taking more than 13 months. When tactically then should expert reports be obtained? Because there's implications for funding. I think it's an absolute nightmare of an issue, isn't it? My view would always be to obtain an expert report at the outset. My view would always be that in order to justify sort of a positive finding on merits and be able to advise positively, I think there are, because BritSit says this has to be supported by expert medical evidence, unfortunately, we have to obtain it at the earliest stage, especially where we're relying on, as Alexander refers to it, as I refer to it, psychosocial requirements. I think you have to get it from the outset. I can understand why there may be sort of a tactical advantage in not doing that and just say, well, look, we're going to get refused anyway, we'll produce it for the substantive hearing. I'm not even saying that's wrong, but I am saying that the correct technical answer must be that if you're relying on psychosocial care requirements, BritSit says you need expert medical evidence, so it has to go in with the application. The way I've tended to do it is to, and just to give a bit of context here, I don't know whether anyone agrees with this approach, but this is the way I've tended to do it. I tend to use UK-based experts that then have a video conference with the applicant in their country of origin, who then prepare an initial report on the basis of that assessment and make sure it's very thorough, preferably across 2 sessions. That goes in with the application. If the health is bad and the health's getting worse, ask for expedition. I know that it's a nightmare. And then, when it comes to the appeal itself, ask the expert to prepare an addendum report, updating us on the current position, whether it's got any worse, whether there's a change in view. So then by the time you get to the appeal, you've got your substantive initial expert's report and you've got a small addendum. That's the way I've done it. That's the way I found is successful. There might be another way of doing it that's successful, but that's the way I do it. Okay, and just in case anyone's wondering, yeah, I have been involved in the preparation of these cases from the outset. I'm always keen to be involved in preparation from the outset because I think team effort is the way to go on these things. So the next way to lose, failing to evidence what the required level of care is. So what you've got to actually ask, what is required? Now, strictly speaking, there's nothing in terms of the required level of care, if it's physical, strictly speaking, there's nothing that says you need expert evidence. But it's in the guidance. Now, you could argue that you can't have a rule in the guidance that's not in the rules, but in my view, easier just to get it. So as you can see, throughout my thinking on this is, yes, it's going to be expensive, but medical evidence is probably necessary for everything. Because in my view, this is why, in my view, even if you've got a physical issue that creates a need for care, you're always going to have a psychosocial issue as well. There's always going to be one. I can't think of a situation where you'd only have a person that has physical needs and doesn't have any psychological needs. So if you've got psychological needs, you're going to plead it. And if you're going to plead it, BritSit says you need expert medical evidence. So if there's ever a concern about necessity, I think that's how it's made out. Quick look at chat before I continue. Nothing further. All right, moving forwards. What's the next way to lose? Yeah, so the obvious way is failing to actually address availability of care in the home country. Now, I know there are countries where it is literally impossible for care to be provided, but let's face it, it's not that common. Most of these situations are going to be that you've got an applicant from a country where there is care. So, again, I can't seem to get away from Pakistan in my mind, thanks example 7, but it's a country where I see a lot of applications for ADR. And the situation in Pakistan is that there's a country policy information note that says there are 2 care homes. but they're in the big cities, right? One of them's in Karachi. I can't think where the other one is. There's two in Pakistan, right? So I've seen people try and argue that there are none, and it's an impossible argument, I think. I don't think it's an argument worth making. What I would always do is say, I accept that they are there, I accept that care can technically be provided, but it won't be to the required level. In other words, it won't deal with my psychosocial needs, or it won't be reasonably available. I accept that it's technically available, but it's not reasonably available because of perhaps cultural issues, religion issues, issues about me having to travel to a part of the country where I've never been and losing what, little recognition of my environment I might still have. I would always say it's so difficult to argue that care is not available. It's much easier and more sensible to argue that it's not reasonably available or doesn't provide the required level of care. What's the 8th way to lose? Family tree. Please, please, please. I just think it's always worth having one page in the bundle as a family tree. And I don't just mean a list of family members. I mean like a proper tree. I've done trees and judges love it. I don't know why. But I think it's because judges always have at the back of their mind this sort of terrifying fear, right, that there's a family member that can provide all this care and I don't know about them. And if you just provide a family tree that sets out every family member, right, so you've got these 2 brothers over here and they're living in the United States, and you've got a sister that's in Germany, and you've got a couple of family members in the UAE, whatever the case may be, and you've got this huge tree, at least a judge can just turn to it and see that you have marked on every family member on the tree a very short little reason as to why they can't provide the care. It might be geographical, it might be that they are in a different part of the country, that's geographical. It might be that they've got a family of their own and they're just, their commitments are saturated. Whatever the case may be, a family tree seems to go down really well in establishing that there is no one else who can reasonably provide the care in the country of origin. What's the next one here? The next one, failing to meet financial requirements. And the easiest way that I've seen people fail with this is in forgetting that if you are making out the case that you can adequately maintain and accommodate your applicant, and you're doing it using, for example, income from employment, you've got to meet the specified evidence requirements. And if you don't, you fail under the rules, right? And you're stuck in the outside the rule. You're stuck having to argue either unjustifiably harsh consequences, or a proportionality exercise, all because there was a bit of specified evidence missing. So yeah, it's always worth going back to a FMSE paragraph 1, paragraph 12, reminding ourselves what documents do we need. It's so easy to fail with this. It's so easy. What's the next one? Oh, you're right. So just to remind ourselves, I'll just make this bigger, as to how complicated the calculation is to show that you can adequately maintain an applicant. You've got to show all this. So there's 3, I'm sure you've all seen this. It's A, B, and C, right? So the top box is A, then it's B, then it's C. And basically, how does it work? A minus B must be greater than or equal to C, right? That's how it works. So you've got to show your weekly net income using specified evidence requirements. I had one recently. Where it was terrifying, right? So I had one where an applicant had relied on income in the form of child support payments, and there's a specific provision in the immigration rules for what, in the specified evidence requirements, for what evidence you need to rely upon child support payments. And it wasn't there. Fail under the rules. Yeah, it's easy to fail. So yeah, essentially what I'm saying is whatever income you're relying on, please, please, please check that there is not a specified evidence requirement for it. And if there is, satisfy it with the application, because if you don't satisfy it with the application, that's it. You're outside the rules. Or you're into difficulties. And the last one, the biggest mistake that I think can be made in an application is expecting the Home Office to figure it out. They refuse so many of these applications. Is it Morpheus in the Matrix that says they've become exceptionally good at it? It's so easy for them to refuse, right? In order to get them to allow, you literally have to spell it out for them with references to BritSits or references to their guidance, because their guidance does refer to BritSits now. And just take the view that they need you to make it easy for them. Sorry if that sounds patronizing, but like it is the difference. So before we finish, we're just going to look at what we do if we can't meet the rules. If you can't meet the rules, you might have to just go for proportionality. Now, go back then to the High Court BritSits decision, because there's really useful paragraphs in there that say, if you can't get in under the rules, but you've got some other weighty consideration, right? So, for example, some sort of relationship, grandparent-grandchild, for example, some sort of weighty relationship that the rules preclude because they don't include them. If it's weighty enough, then the court in BritSits said, have less regard to the fact that you don't meet the rules. But a much easier approach, if you can't meet the rules we've already discussed, is to go through the Article 8 route that is now contained within Appendix ADR, which is ADR 7.1 and 7.2. This requires the decision maker, or more likely the court, to consider whether or not refusal of entry clearance would result in unjustifiably harsh consequences. And the approach that I think is sensible to take here is this. It's not unduly harsh. It's not like deportation. It's unjustifiably harsh. Justified with comparison to what, right? It must only be the legitimate aim. What's the legitimate aim of Appendix ADR? It's to save the NHS money, right? Everywhere you look in the history of Appendix ADR, the whole point of it is concerns that the NHS is being cost too much by people in late stages of life that have high care needs. So, is there an argument that you can make that it's unjustifiably harsh to deprive a person of access when you know that it's being justified against the need to protect the NHS from excess cost? So, for example, one thing that I've always wanted to see argued, but I've never seen it, is I'm going to cover this person on private health insurance, right? I've taken out a policy in advance. They have private health insurance. So the harshness of the consequence of their lack of admission can't be justified, because it could only be justified if they were at risk of costing the NHS money, and I've made sure they won't. I think that's a sensible argument to make. I'd love to see that argument made from a family that might be in a position financially, a strong position financially, to privately insure somebody. Maybe there are problems with that. Maybe that's why it's never been done. How extensive should a family tree be? Some family trees are very large and complex. I would say it needs to extend to include all cousins. So I would say it needs to extend to include all children of sisters and brothers. That's as far as I would go. Good question, though. I think going further than that is probably unnecessary, because, yeah, I know if you go beyond cousins, it gets absolutely colossal. And obviously, you could go that way as well. I think that's probably unnecessary. But that's just my view, right? That's just my view from practice. And that takes us to the end. All right, so we've pretty much bang on time. So at this point, feel free to leave and get on with your day, or enjoy an early start to the weekend. We've got some potentially nice weather coming. Not as nice as this, but you know, it's warmer than it was. But otherwise, I'm going to hang around for 10 minutes and answer any questions that anyone's got. Alexander is asking a question. Let's talk. I can see you typing, Alexander. You can't delete it now. You've got to finish. I've just realised there's a Q&A thing that's gone off. It's the questions in the Q&A. Usha's got a question in the Q&A. I'll have a look at that in one sec. Let me just see what. Alexander's not finished typing yet, so I'll go to the Q&A. We're gonna go on until 2:10 and then end this. Use UK experts often use memory boards in relation to in-country FLRFP applications. House of Lords joint report from February 2023 saying ADR route was effectively shut. Yeah. So I think this is the point that Britsits were making in the 2016 case, was that when you look at the extent to which, let's just say, for example, parents and grandparents made successful settlement applications post-2012, it just drops off a cliff. And I think it is a sensible thing to say. When you can point to certain years where one application was successful, you have effectively closed that route. Often use memory boards in relation to in-country FLR applications. Can you expand on that, Usha? I'd love to hear a bit more about that. Alexander says, just wanted to ensure that all of these considerations are broadly applicable to in-country Article 8 cases. So yeah, obviously, if you're in country, you technically don't have access to ADR at all. So yes, I would say they probably are broadly applicable to in-country Article 8 cases. What if you have a situation, though, right, where you have a person who's in the UK, I've had a few of these, because let's say they arrived in, February 2020 on a 6-month visa, and then they just got stuck here. And while they were stuck here, their health just tanks, and they end up in a position where they meet the requirements of the ADR rules, apart from the fact that they're in the UK. I think in those situations, you go to ADR 7.1 or 7.2, and you say that it would be unjustifiably harsh to refuse that person's settlement simply because they're in the UK. It's like a Chikwamba argument, isn't it? It's a Chikwamba argument that can actually succeed. I think that's the way to do that. So that's, I suppose, a broad Article 8 case. Maybe it's not that broad. Oh no, oh no, it's okay. I thought there's been somebody that's been waiting to come in. Usha's got your hand up. Usha, your hand's up. Is it from your Q&A? Where in-country applicants have dementia, the in-country ADR point is taken as Chikwamba. But because the thing is, the problem that I see it is, as soon as you say the word Chikwamba nowadays, you're on the back foot, aren't you? Because we've got, what are those authorities we've had recently that say, Chikwamba is almost dead? It's not, and I'd almost be like, in a hearing, I think I would be saying, this isn't Chikwamba, this isn't Chikwamba, this is ADR 7.1. I am arguing unjustifiably harsh consequences. I am arguing that the Secretary of State couldn't possibly say that it's justified to refuse a person settlement in the UK when they are saying that they would accept them if they went back to their home country and made an application from there, especially where we know that that would mean they'd be stuck in that other country for at least 12 months. At least 12 months. Can I assist anyone else any further? Are there any further thoughts or questions? Would you advise then to avoid references? Yeah, I would, honestly. I'm saying that it's like Chikwamba, right? To just amongst us. It is. It's got the hallmarks of Chikwamba because it's basically saying, don't return me just for the sake of making an application when everything else succeeds. But I wouldn't use the word. I wouldn't use the word because I think more and more the judiciary and decision makers are thinking, Chikwamba's dead. Chikwamba doesn't exist anymore, which is also not true, but why have the argument? It's just unjustifiably harsh. 7.1. Got a few minutes left if anyone's got any more questions. Otherwise, I will love you and leave you to have a lovely weekend and try and continue to fight this fight all across the UK. Second worst in the world. You're very welcome, Georgette. You're very welcome. I hope it's been useful. There's so much to cover in this. It could easily be a course. You know what I mean? You could easily just have a course on how to do ADR applications. And I don't know that I've got the best way, but I do know that I'm succeeding, against the odds, which is what you want, isn't it? Okay, that's time for today, folks. So all the best to everyone. Look after yourselves. Have a great weekend. If you've got any questions that arise after the meeting, please feel free to email them over. And until next time, I've been Jonathan Holt, and this is Goodbye. Thank you very much for joining. Goodbye.